Hi, this is Michael Helfand. Welcome again to No Harm, No Foul, where we'll be exploring to what extent does American law actually embrace this principle when it comes to using other people's property. Today we're going to talk about the case of the unused egg washing machine. You're probably wondering what an egg washing machine is, but before we get to that, just a quick recap of where we're up to. As you may recall, we began by thinking about two cases. What happens when I use somebody's internet that doesn't belong to me? Or what happens when I go and take a seat at a baseball game that I haven't actually paid for? In each of those instances, we noted how I shouldn't necessarily have to pay for either using that internet or taking the seat I haven't paid for under a principle of contract, because we didn't agree for me to pay anything if I used your internet or moved up and took a better seat. And I shouldn't have to pay as a matter of tort law. I didn't damage you, I didn't punch you in the face or trespass on your property because, I just took a little bit of bandwidth, extremely minimal damage. Or I used a seat that was empty in a baseball stadium moving up to get that better view. There was no damage, you couldn't sell the seat anyway. But we did note that even though contract and tort didn't provide reasons to be liable, there was this in-between concept, unjust enrichment and restitution. This idea that if I'm unjustly enriched, I have to make restitution. I have to restore the person's property whose property I've used, in instances, again, where I am unjustly enriched. And we tried to figure out what on earth does this mean. We looked at one case, the case of the Great Onyx Cave. Here we had two neighbors, Edwards and Lee. Edward is making tons of money bringing people into this cave underneath his property, showing them the beauty of his cave. But it happens to be that part of that cave is also owned by Lee. Lee can't get into the property. There's no way he's going to be able to rent the property. But Lee is, we learned from the Kentucky Supreme Court, Lee is able to collect some money from Edwards, even though Lee really isn't damaged by the fact that Edwards is using the piece of the cave that belongs to Lee. Lee can't rent it, but he still gets the profits that Edwards makes by bringing people in, by charging them admission to show them the cave. Now, what I want to tell you today is this isn't only true, this concept that I can collect the profits from somebody else when they come and use my property. It's not just about land, but it's also about items, tangible, movable goods. And I want to show that to you through the case of the unused egg washing machine from 1946. What is an egg washing machine? Well, it looks something like this. It washes eggs. And in 1946, it would have cost you $10 a week to hire people to wash eggs. But if you had an egg washing machine, you could save those $10 a week. Well, we have the following case that comes up in Washington, in the state of Washington. There's a company, an egg packing company, that has on its plant, like any other egg packing company, it's packing eggs, but next to the plant, in property that it doesn't own, there is actually an unused egg washing machine, owned by somebody else. The land isn't theirs. However, that person wasn't able to make use of that egg washing machine because it was too far away, and there's no way for him to move that egg washing machine to his own egg packing plant. You know why? Well, this was all going on during World War II, and there was no labor around to move this egg washing machine, and so it just sat there next to this egg packing plant that really could use the egg washing machine. And so you know what this company did? It went and it took the egg washing machine out of storage, brought it onto its own property, and started using it for 3 years. For 3 years, this egg packing company made use of the egg washing machine, saving $10 a week. Well, not surprisingly, when the owner of the egg washing machine found out, he wanted to get paid. He wanted to get paid for the use of the egg washing machine. Should the egg packing company have to pay? I mean, this egg washing machine was just sitting in storage. Why on earth should this egg packing company have to pay? The owner of the egg washing machine didn't lose anything at all. Well, that's not what the Washington Supreme Court said. The defendant cannot be heard to say that its wrongful invasion of the plaintiff's property right to exclusive use is not a loss compensable in law. To hold otherwise would be subversive of all property rights, since its use was admittedly wrongful and without claim of right. Here's the idea the court's trying to convey. It can't be the case that the defendant can say, you know what, you didn't lose anything by my using your egg washing machine, so there's no real loss here that's compensable in law, that the law is going to require me to compensate you for. Because if that were true, there would be no property rights at all. I could just come, take your stuff, use it, and as long as it didn't harm you in any way, there was nothing you as the property owner could do to stop me. You could say as much as you want, this is my property, but it doesn't matter. As long as I'm not damaging you, then I can use your property. That's what it would be to say that people like this egg packing company can come and use your egg washing machine as long as there's no loss, as long as there's no harm. And the court says there's no way that we could allow a defendant to say such a thing. Instead, what we actually need to say is the following. If the defendant was tortious in his acquisition of the benefit, he is required to pay for what the other has lost. And not just that. If he was consciously tortious in acquiring the benefit, he is also deprived of any profit derived from his subsequent dealing with it. Here's what the court's conveying again. When you come and you're tortious and you wrongfully grab hold of my property, you have to pay for what I've lost. Now, of course, in the egg washing case, the loss was really nothing, right? I mean, the egg washing machine wasn't being used. But that's not it. If you're consciously tortious, you know you're being wrongful, and you come and you grab my property, you don't just pay for what's lost. You also get the profit derived from his subsequent dealing with it. If you're the egg washing company and you come and take my property intentionally and you wrongfully use it, I get the profit that you derived from using my property. Just like we talked about in the case of the Great Onyx Cave, it's not just about what harm you impose on somebody else. But the law says, you know what? It's not just that, but you also, the person who has lost the ability to use their property because somebody else has come and grabbed it from them, that person is entitled to the profits that were made off of his property. Not just the damages, not just the harm, but also the profits derived.